Hi, I'm attorney Marshall Hong from immigrationinfosite.com. In this short video, I will briefly describe the different family categories that qualify for immigration benefits. If you would like to help one of your family members immigrate to the United States, this video will help you determine whether you can do so. First, you, the petitioner, must be either a citizen of the United States or a permanent resident of the United States. If you are a U.S. citizen, either by birth in the United States, by having gone through the naturalization process, or by having derived citizenship from one of your parents, you can petition for the following members to immigrate to the United States: parents, spouse, meaning your husband or your wife, children, unmarried sons and daughters, married sons and daughters, and siblings, meaning brothers and sisters. If you are a permanent resident, including conditional residents, you can petition for your spouse, meaning your husband or your wife, your children, and unmarried sons and daughters. To petition for your husband or your wife, your marriage must be both valid and bona fide. To be valid, the marriage must have been lawfully entered into and must be recognized as lawful in the jurisdiction in which the marriage took place. Both parties must have been free to enter into the marriage at the time that they were married. In other words, if either party was previously married, all prior marriages must have been terminated either by death, by divorce, or by invalidation. To be bona fide, the marriage must have been entered into in good faith. This means that the marriage was not entered into solely for the purpose of gaining immigration benefits or evading immigration laws. Rather, the parties must have entered into the marriage because they intend to have a shared life together. Presently, same-sex marriages are not recognized for immigration law purposes. While certain states do recognize same-sex marriages, immigration law does not allow for a petitioner to petition for a same-sex spouse. For immigration law purposes, the terms child and children include children who are under the age of 21 years and who are not married. If the child is over 21 years old or married or both, they are no longer considered a child, but rather a son or a daughter, either a married son or daughter or an unmarried son or daughter. As previously mentioned, a U.S. citizen can petition for unmarried sons and daughters as well as married sons and daughters, whereas a permanent resident can only petition for unmarried sons and daughters. For immigration purposes, the category of children also includes stepchildren and adopted children under certain conditions. To petition for a stepchild, the marriage that created that step relationship must have been entered into prior to that child reaching the age of 18. To petition for an adopted child, the adoption must have been completed prior to the child reaching the age of 16, except where the child was adopted prior to reaching the age of 18 at the same time as a younger sibling who had not yet reached the age of 16, then both of those children who were adopted will be considered children for immigration law purposes. A U.S. citizen can petition for his or her parents, including biological parents, step-parents, and adoptive parents where certain conditions are met. For a U.S. citizen to petition for a step-parent, the marriage that created that step relationship must have been entered into prior to that U.S. citizen child reaching the age of 18. For a U.S. citizen to petition for an adoptive parent, the adoption must have been completed prior to that U.S. citizen child having reached the age of 16. Unless the adoption occurred before that child reached the age of 18, and the child was adopted at the same time as a younger sibling who had not yet reached the age of 16. A U.S. citizen can petition for his or her brothers or sisters as long as they share at least one parent in common. So if they have the same mother or the same father, or of course both parents in common, then the U.S. citizen can petition for that brother or sister. A U.S. citizen can also petition for a fiancé when certain conditions are met. Both parties must be free to enter into the marriage, meaning any and all prior marriages have been terminated. The parties must intend to conclude a marriage within 90 days after the fiancé enters the United States. And the parties must have met in person at least one time during the 2-year period immediately prior to filing the fiancé petition. If your family member does not fall into one of the categories I've just described, then in general, you cannot petition for that family member. As an example, a U.S. citizen cannot petition for grandparents, grandchildren, cousins, aunts, uncles, nieces, or nephews, unless that family member falls into one of the categories I've described through an adoption. So, for example, if a U.S. citizen were to adopt a niece or a nephew and certain other conditions are met, then that U.S. citizen can petition for that niece or nephew as an adopted child. Another example, a permanent resident cannot petition for parents, a permanent resident cannot petition for brothers and sisters, a permanent resident cannot petition for his or her fiancé, and a permanent resident cannot petition for married sons and daughters. In some cases, it may be possible for a U.S. citizen or a permanent resident to assist a family member to immigrate to the United States based not on the family relationship, but rather on an offer of employment from the petitioner's company. That issue will not be discussed in this video. However, please check back at www.immigrationinfosite.com for other videos, articles, or other materials discussing employment-related immigration. Before I conclude, I would like to briefly mention a couple of other categories that are based on relationships to U.S. citizens. These include the widow of a U.S. citizen when certain conditions are met, and also the spouse or children of a U.S. citizen who have been the victims of domestic violence at the hands of their U.S. citizen spouse or parent. These individuals may be able to self-petition to become permanent residents without the participation of their U.S. citizen family member. This video is being presented only as a general overview of the different family categories available for immigration. If you have specific questions related to your individual circumstances, you may wish to consult with a qualified immigration attorney in your area. You can also contact us at www.immigrationinfosite.com or www.hong-immigration.com. You can email me directly at marshall@hong-immigration.com. Thank you, and be sure to check back at www.immigrationinfosite.com for more videos, articles, and other materials to help answer your immigration law questions.